Could pragmatism be the key to unlocking a more effective, just legal system? This is the provocative question that animates Richard Posner's intriguing book, Law, Pragmatism, and Democracy. As a renowned legal scholar and judge, Posner is bold enough to suggest an affirmative response. Voiceover. Following the introduction of Posner's thesis, we delve deeper into the first chapter of his book, where he lays the theoretical groundwork for his argument. Here, Posner introduces us to the concept of pragmatism, an approach that prioritizes the practical implications of decisions over rigid adherence to theoretical principles. He explains how pragmatism, with its emphasis on the practical, is inherently suited to both law and democracy. In a democratic society, laws are supposed to serve the people, and what better way to do so than by focusing on the real-world consequences of legal decisions? Posner's argument for a pragmatic approach to law is compelling. He contends that by focusing on the practical implications of legal decisions, we can create a more effective and just legal system. This, he believes, is the essence of a democratic legal system: laws that work for the people, not against them. This chapter sets the stage for the rest of the book, providing a theoretical foundation for Posner's pragmatic approach to law. It invites us to think critically about the role of pragmatism in our legal system, setting us up for the discussions to come in the subsequent chapters. Stay tuned as we explore the importance of pragmatism in the legal system in Scene 3. Voiceover. In the second chapter, Posner delves deeper into the relationship between pragmatism and legal theory. He explores how pragmatism, with its focus on practical implications and outcomes, can be applied to legal theory. Traditional legal theories, Posner argues, often prioritize abstract principles over the real-world effects of legal decisions. This, he contends, can lead to unjust outcomes that do not serve the interests of the people. Posner critiques these traditional legal theories, highlighting their limitations and arguing that they often fail to consider the practical implications of legal decisions. He contends that a pragmatic approach to legal theory, on the other hand, can lead to more just and effective outcomes. By focusing on the real-world effects of legal decisions, pragmatism ensures that the law serves the interests of the people, which is the essence of a democratic legal system. Posner makes a compelling case for the application of pragmatism in legal theory, challenging traditional legal theories and advocating for a more practical approach. He demonstrates that pragmatism offers a more effective and just approach to legal theory, one that prioritizes the practical implications of legal decisions over abstract principles. As we continue our exploration of Posner's thesis, keep this idea in mind: the importance of pragmatism in the legal system. This concept will be central to our discussion in the next scene, where we delve deeper into the role of pragmatism in the legal system. Stay tuned. Voiceover. As we turn the page to Chapter 3, Posner focuses his lens on constitutional law, showcasing the practical application of pragmatism in this arena. He challenges the conventional wisdom of strict constitutional interpretation, arguing that such rigidity can often lead to unjust results and societal discord. Instead, he advocates for a more flexible, pragmatic approach, one that takes into account the real-world consequences of legal decisions. Posner critiques the traditional approach to constitutional law, often characterized by a strict adherence to the text. He argues that this approach can be too rigid, failing to account for the complex realities of modern society and the evolving understanding of justice and fairness. He highlights the risk of adhering too strictly to the original text, which can lead to outcomes that are at odds with the principles of democracy and justice. In contrast to this, Posner advocates for a pragmatic approach to constitutional law. He argues that by focusing on the practical implications of legal decisions, we can ensure that the law remains responsive to societal needs and continues to serve the interests of the people. He contends that a pragmatic approach to constitutional law can lead to more just and effective outcomes, better reflecting the values of a democratic society. In conclusion, Posner presents a compelling case for the application of pragmatism in constitutional law. He challenges traditional legal theories, advocating for a more practical approach that prioritizes the real-world effects of legal decisions. As we delve deeper into Posner's thesis in the next scene, keep in mind this core idea: the importance of pragmatism in the legal system. This concept is central to our understanding of Posner's overall argument. Stay tuned. Voiceover. In the fourth chapter, Posner's exploration takes us through the intriguing realm of statutory interpretation. Here, he continues to apply his distinctive pragmatic lens, dissecting the complexities of interpreting legislation. Traditional methods of statutory interpretation often focus on the original intent of lawmakers or the strict letter of the law, sometimes overlooking the real-world implications. Posner critiques this rigid approach, highlighting its limitations. He argues that such traditional methods can result in a static interpretation of the law, failing to account for societal changes and evolving norms. This rigidity, Posner posits, can lead to outcomes that are out of touch with the realities of the modern world and the principles of justice and fairness. Posner then presents his argument for a pragmatic approach to statutory interpretation. He advocates for a method that takes into consideration the practical effects of interpretation, emphasizing the need for the law to adapt and respond to societal changes. Posner's pragmatic approach aims to ensure that the interpretation of statutes remains relevant and effective, fostering a legal system that serves the interests of the people and the principles of democracy. In conclusion, Posner makes a compelling case for the application of pragmatism in statutory interpretation, challenging traditional methods and advocating for a more practical approach. As we move forward, keep in mind Posner's insistence on the importance of pragmatism, not just in constitutional law, but across the entire legal system. It's a theme that will continue to resonate as we delve deeper into his work. Stay tuned for the next scene where we further explore the importance of pragmatism in the legal system. Voiceover. Chapter 5 of Posner's exploration takes us into the realm of legal education. Posner critiques the traditional approach, which often emphasizes legal theory and abstract principles over practical application. He notes that this method, while academically rigorous, can leave law students ill-prepared for the realities of legal practice. Posner asserts that traditional legal education often fails to equip students with the necessary skills to navigate the complexities and uncertainties of the legal world. Transitioning, Posner then advocates for a pragmatic approach to legal education. This approach, he argues, should focus not only on theoretical knowledge, but also on practical skills such as problem-solving, negotiation, and the ability to adapt to changing circumstances. Posner posits that a pragmatic approach to legal education better prepares law students to handle real-world situations, making them more effective and adaptable legal practitioners. The potential benefits of a pragmatic approach to legal education, Posner suggests, are significant. It could lead to more effective legal professionals who are better equipped to serve the interests of their clients and the principles of justice. Moreover, it could foster a more responsive and adaptive legal system, capable of addressing the evolving needs of society. In conclusion, Posner argues that a pragmatic approach to legal education can better prepare law students for the realities of legal practice. It's a compelling argument that underscores the importance of pragmatism, not just in interpreting the law, but in teaching it as well. Stay tuned as we delve deeper into the importance of pragmatism in the legal system in the next scene. Posner's central thesis revolves around the importance of pragmatism in the legal system. He advocates for an approach that emphasizes the practical consequences of legal decisions, as opposed to a rigid adherence to abstract principles. This, Posner argues, leads to more just and effective outcomes that are better suited to a democratic society. The book also delves into the relationship between the judiciary and democracy. Posner explores how judicial decisions, steeped in pragmatic considerations, can significantly impact democratic processes and outcomes. He presents a compelling case for the judiciary's role in not just interpreting the law, but also in shaping it to better reflect societal realities. Law, Pragmatism, and Democracy further introduces readers to the concept of legal realism. This approach underscores the need to consider real-world consequences and societal context when interpreting the law, a view that aligns with Posner's advocacy for pragmatism. Posner also contrasts legal positivism, which reveres the authority of written law, with his favored approach of pragmatism, which prioritizes practical outcomes. This contrast sparks a lively discussion on the merits and drawbacks of each philosophy, prompting readers to critically evaluate their own legal perspectives. Moving beyond theoretical debates, Posner dissects the tension between judicial activism and restraint. He posits that a pragmatic approach can help strike a balance, allowing judges to shape and interpret the law in a manner that is both responsible and responsive to societal needs. The book concludes with a thoughtful exploration of how technological advancements and societal changes challenge traditional legal frameworks. Posner argues that pragmatism can help the legal system adapt to these changes, ensuring that it remains effective and relevant in an ever-evolving world. In conclusion, Law, Pragmatism, and Democracy by Richard Posner offers a compelling argument for the central role of pragmatism in law and democracy. It explores the dynamic between the judiciary and democratic governance, the concept of legal realism, the contrasting philosophies of legal positivism and pragmatism, the debate between judicial activism and restraint, and the impact of technology and social change on the legal system. This exploration underscores the importance of balancing legal principles with practical considerations, a balance that Posner argues is essential for a robust, functioning democratic legal system. The relevance of Law, Pragmatism, and Democracy by Richard Posner remains significant in contemporary legal and political discourse. Here are a few reasons why. 1. Posner's exploration of pragmatism in legal decision-making continues to inform debates about how judges should approach interpreting and applying the law. In an era of complex legal issues and societal challenges, the question of whether judges should prioritize pragmatism over strict adherence to legal principles remains relevant. 1. Posner's analysis of the relationship between the judiciary and democratic governance addresses ongoing concerns about the role of courts in shaping public policy and democratic outcomes. Discussions about judicial activism, judicial independence, and the accountability of judges to democratic principles often draw upon the themes explored in Posner's work. 1. The concept of legal realism, which Posner discusses in the book, remains relevant in understanding how legal decisions are influenced by societal context and practical consequences. As legal issues intersect with evolving social norms, technological advancements, and economic changes, the need for a pragmatic approach to legal interpretation becomes increasingly apparent. 1. Posner's exploration of legal positivism versus pragmatism contributes to ongoing debates within legal theory about the nature of law and the role of judges in its interpretation. These debates shape how legal scholars, practitioners, and policymakers understand the foundations of the legal system and its implications for society. Overall, Law, Pragmatism, and Democracy continues to be relevant for understanding the complexities of law, governance, and democracy in contemporary society, providing insights into how legal systems can adapt to meet the challenges of the modern world. In this part, we will delve into some of the criticisms and counter-arguments to Richard Posner's Law, Pragmatism, and Democracy. Here are some key points of contention. 1. Judicial activism critique. Some critics argue that Posner's pragmatism could be seen as a green light for judicial activism. They suggest that it could lead judges to overstep their boundaries and make policy decisions that should be left to elected representatives. This, they argue, undermines democratic accountability and the separation of powers. 1. Concerns regarding legal indeterminacy. The emphasis Posner places on pragmatism and real-world considerations in judicial decision-making has led to concerns about legal indeterminacy. Critics suggest that prioritizing pragmatic outcomes over clear legal principles could create inconsistency and uncertainty in the law, making it more challenging for individuals and businesses to predict legal outcomes. 1. Rejection of legal formalism. Critique. Posner's dismissal of legal formalism, which stresses the strict application of legal rules and principles, has faced criticism. Critics argue that formalism provides clarity and predictability in legal reasoning, which promotes the rule of law and ensures equal treatment under the law. 1. Questioning the role of judges. Posner's views on the role of judges in interpreting and shaping the law have sparked debate about the appropriate boundaries of judicial authority. Critics raise concerns about the potential for judicial overreach and the erosion of democratic principles if judges are given too much discretion to make policy decisions. 1. Response to social and political context. Some critics argue that Posner's pragmatism may not adequately address structural inequalities and power imbalances in society. They suggest that a purely pragmatic approach to legal decision-making may fail to address systemic injustices and marginalized voices. In conclusion, while Posner's work has stimulated important discussions about the role of pragmatism in law and democracy, it has also prompted critiques and debates about the implications of his views for the legal system and society as a whole.